I can deploy you.
Redeploy you.
Yeah, or redeploy you to the position of Mr. Minister Mtuku's. He's absent from work, unable to
Is absent from office. Yeah.
right? Why is that wrong?
No, it's not wrong. It's just not what happened here. The president should have come to you before what you are saying, there's nothing wrong with it, but it is most decidedly not what was done. That would be nice, and it would be constitutional. But what you cannot do, that advice, you can't have it after the fact. That's what's called ex post facto rationalization. What the president did, Justice Matopo, did in actual fact, was to say, I am appointing Professor Kachalia as an acting minister. And he says that not just in the announcement, as I've explained to Justice Chikwi, he even says it in his answering affidavit. So he's clear about what capacity he was appointing Professor Kachalia into, acting minister. He cannot do such a thing under Section 91(3)(c), because Section 91(3)(c) is to appoint ministers per se from the general public or from the National Assembly. Where he can appoint him as an acting minister is under Section 98. But the problem he has there is Section 98 says, for me to make you an acting minister, you must already be a cabinet minister.
But you would be a cabinet minister in terms of 91(3). But you said it's, I think where I have a difference with you
yes,
is you seem to be putting more emphasis on the appointment itself.
Yes, but
On the announcement, sorry.
No.
Yeah, you seem to be putting emphasis on the announcement. Let me put it this way.
Page 91, paragraph 57 of the I think it's volume 1 or volume A, I think it's called.
And that would be what under which heading? Just
that's the first page 91, paginated page 91, Justice Maton.
I need to get there. This is a very important point for me.
It is. No, it is indeed.
Yeah, what paragraph is that?
57, Justice. I've elected to appoint an acting minister of police from outside cabinet, as I'm entitled to do in terms of Section 91(3)(c). That's a misstatement of the law. Section 91(3)(c) does not entitle him to elect to appoint an acting minister of police. The section which he was obviously oblivious of, which entitles him to appoint an acting minister, is Section 98.
But Mr. Mpofu, I think we're quibbling with words. There is no way that the president could have appointed an acting minister from outside.
Well, that's what he says, under oath. So we must tell him he's lying. There's no way, but there's a way, because that's exactly what he did.
No, I can't take it any further.
Well, we wouldn't be here, Justice Matopo. The only reason we're here is because the President Ramaphosa says, I swear before God that I have elected to appoint an acting minister of police from outside the cabinet.
But is this not the debate that you have with my sister, Teron, that we put in form over substance?
Well, maybe. It looks like it is. But the point is...
But it looks more like it looks more like it, not any other way.
But no, Justice Matopo, with the greatest respect, what you are doing is actually doing the right thing, that no president in his right mind could appoint an acting minister from outside the cabinet in terms of 93(1)(c).
You know,
we agree.
It is wrong.
Thank you.
Yeah.
Please. Justice Majid.
Mr. Mpofu, just exclusive jurisdiction. You rightly said that one must have regard to the pleadings to determine exclusive jurisdiction. Can I take you to paragraphs 13 and 14 of the founding affidavits, pages 9 and
1.3 and 1.4, yes. I'm there, Justice.
Yes, now, you mentioned section 167(4) and you mentioned Nkandla and my vote count, but you don't mention section 83 there. What must we make of that?
No, but Justice Machit, with the greatest respect, yeah. The pleadings, when you say the pleadings, you mean the pleadings as a whole, not one paragraph. So section 83 is if you go to,
Can I just stop?
yes,
Page 9C, exclusive jurisdiction and direct access.
yeah,
Then you deal at 13 and 14 with exclusive jurisdiction. Then 15, you.
yes. No, there's nothing wrong with that, Justice Machit. All I'm saying is that when you look at pleadings, the pleadings, you look at the pleadings as a whole. So if you go to paragraph 39, you'll see where, 40 rather, yeah, where we outline the requirements of section 83, okay? And if you go to, where it says the president must uphold, defend, and respect the constitution as supreme law or whatever, then you'll also find in...
Mr. Mpofu, sorry to interrupt you, but I mean, here you're dealing with the merits of the case. You've dealt with exclusive jurisdiction and direct access. These you quote in the context of these three issues that we did.
Yes, but that's what it means when it says the pleadings. It means the pleadings, including the merits. The pleadings,
Is that your
as
answer?
they stand.
Is that your answer?
Yes. In Kaba, it says to find
Can I
jurisdiction.
go to the second aspect? I'm satisfied. Thank you.
Thank you.
There was something that struck me in this case about the Commission of Inquiry.
Right.
And you mentioned earlier, the entire judiciary is tainted by these allegations.
The entire?
Judiciary.
Yes.
You even spelled it out, judiciary,
Yeah.
which includes the entire judges of the country.
That's what it says.
That's what you said.
No, that's what Mkhwanazi says.
You know what he says, yeah. You say, therefore, Justice Madlanga is disqualified from hearing,
No.
from sitting in the Judicial Commission, because he's a judge. You
It's
said it
got
should have been a commission, and then it would have other problems.
No. It's got nothing to do with Justice Matlanga. It says there is a species of Nemo Iudex called institutional bias.
understand that. Yes.
So it's the institution, not Justice Matlanga.
Understand that. That's why I'm
That
saying,
is standing in the dock.
yeah. The entire judiciary is
in the dock.
disqualified as an institution.
Is in the dock, yes.
But why is the case in this court before the judges? How are we qualified to hear this case and he's disqualified as a judge of the institution to? I hope I'm not sounding facetious.
No,
But it just
well,
occurred to me,
I
it's
want
a
to answer
different
that
thing,
question.
because we are asked to decide this challenge, which goes to the heart of the establishment of the commission. So how are we qualified, but another judge, a member of the institution, is disqualified? Qua judge.
No, but Justice Machit, you are qualified because you swore when you were being admitted as a judge to apply the Constitution of the Republic of South Africa. And we are saying here that in the leave of absence decision, the Republic of South Africa, the Constitution of the Republic of South Africa was breached. That's got nothing to do with Justice Matlanga or anybody. We say the appointment of Acting Minister Kachalia was unconstitutional and all the things that we say. That has got nothing to do with this. And we say in relation to the commission that the judiciary is conflicted. I'm putting it colloquially. Now, every time, in fact, when you do a recusal, you do it to the judge. So the judge can say, well, why are you asking me? What is that? Because the judge is compelled by his or her oath of office, even when the recusal is against him or her, to adjudicate it. So,
Understand it. I mean, you're talking about an institution, the judiciary, but I hear you. I hear your answer. Now, just lastly, you say, and I'm dealing with a leave of absence, because as you say, but for the leave of absence, we wouldn't have had an appointment of the professor. Now, you say there are only two possibilities in the exercise of his presidential prerogative. The president can only appoint and dismiss. There's nothing in between. There's no room for suspension or placing on leave, as he calls it.
well, I say two things. I say, to the extent that leave of absence is definitely no power for the reasons that I've explained, because you can't place someone on leave of absence. But if you take Justice Theron's formulation to say, okay, well, let's arose by any name. Let's say it was a suspension. Then I've answered that. I referred the court to 177 to...
Can I ask you about 177 then?
Yeah.
Because we've heard that 177 deals with a judge being removed from office, and 194 deals with head
of Chapter 9.
of Chapter 9 institution. Is the word suspension there not deliberately used because there are other actors at play here? It's not just the president who takes a decision, I'm going to appoint or dismiss a minister, but here we have the National Assembly that must, through a vote,
Sorry, Justice.
oh, sure, must through a vote to remove them, a judge or a Chapter 9 institution
Right.
holder. Is that not the reason why the president is expressly given the power to suspend there? And therefore, there is no such express provision here, because it's his prerogative, it's his discretion, it's his power. He's empowered to do so without any outside actors like the National Assembly.
No, firstly, because even in the other, if you look at 194.3, 194.3A is also a prerogative, so that's not a reason.
There, the National Assembly plays a role. Do you accept that?
No, of course, that's for a different reason. That's because it's a punitive removal. And because it's a punitive removal, this court said in EFF 2, because it's a punitive removal, you must have a process, a disciplinary process, for lack of a better word. You must. It's necessary. That's where the necessity test comes in. There, you said, Justice Machiti Mwabe, that the test is necessity. In those examples that you're giving me, it is necessary because there has to be an inquiry. And that's why Justice Jafta and Justice Zondo, for that matter, even in the dissent in EFF 2, made the distinction between an impeachment and a motion of no confidence. The one requires an inquiry because it is punitive, but the other one, because it's a prerogative, in this case, it's a prerogative of Parliament, let's say, to remove you in a motion of no confidence. You don't need an inquiry, so it's not necessary.
And lastly, just on this, on the same topic, the Constitution says we must have regard to international law. It's noticeable, and within the limited time available, it's noticeable that of countries with constitutions more or less resembling our own, for yeah, I'm just leaving out the US for now, but Germany, India, Namibia, and Canada have no express provisions to remove, to suspend ministers or cabinet secretaries. The only one that does have, and through an act of parliament, is Kenya. Is there anything that we must make of that? In other words, in those jurisdictions, it's an implied ancillary power of the type encapsulated in Amabungane and the Madlanga J judgment.
No, the first part is correct, the second part is incorrect. It doesn't follow that because it's not mentioned in other constitution, it means it's an implied power. It means it's not existent. So yes, it's true that in fact, to be fair, even in the so-called common law countries, because this thing comes from Britain in the end, there, because the two things, there's a culture of people just resigning when these kinds of allegations are made. We don't have that culture. But there is the Queen and the Prime Minister. It's said in typical British fashion, it's in the gift of the Prime Minister to have you as a member of the cabinet. But here, the point I was simply making, Justice, was that you can't imply, if you use the test that you gave in Mwabe and the test that's given in Amabungane, and for that matter, the test given in Masetla, you can't imply that the power to place on special leave, assume there's such a thing, the power to place on special leave is so connected as the breaking of the egg when you are making the omelette in the example that Hoekstra makes. In other words, you can't make the omelette without breaking the egg. So you can't say you can't dismiss without leave of absence. That would be far-fetched.
That means that if a minister is accused in the public domain of something that's less serious than would have warranted removal, the president must then dismiss. Yeah, no, there's no in between. There's only appointment and dismissal.
Yeah, can dismiss or retain. There's nothing wrong with him retaining.
There's no via media.
No, there can't be. The only via media, it can't be in our heads. The via media must come from the law.